back in April, what we're looking at is the governor signing into law a change to community-based Medicaid. And there was some time laid out for the law to be implemented. There were some postponements and some changes, but it's all in regard to community Medicaid. And that's what I'm going to be talking about today. It's also important to realize that this does not only apply to those that need Medicaid at this point. This is for all seniors. The reason this is for all seniors is because it also applies to those that don't need the care at this point. Why? Because there will be a look back period or a waiting period for those that need home care. And just like we've been telling families that perhaps are planning for nursing home care down the road, you have to do it in advance. So whether you're younger and or a healthier senior, or whether you are in need of care, this applies to you. Action needs to be taken before the new law is implemented. All right. When though? That's the big question. So here we go. Some overview. As we get older, and those of you that have been on these before, you've seen this, but bear with me. It's just a reminder. As we get older, we can have different issues, different things occur to us. Those that can be what I call medical in nature, as well as those that can be long-term care in nature. Now, those that are medical in nature, those are the ones where we go to the doctor. We go to a hospital, we go to a rehabilitation center, receive physical therapy, speech therapy, occupational therapy. Those are medical needs, and therefore our health insurance or our Medicare and our secondary or supplemental coverage is paying and footing the bill, hopefully most of it, if not all. But on the other side of that coin, we have needs and issues that aren't medical in nature, at least not defined to be medical. And that is the long-term care side of what we're talking about. So if you need assistance, for example, with functional items, what are called the activities of daily living, that is not medical in nature. It's functional, it's custodial, it's chronic, it's long-term care. So examples of these functional needs or these long-term care needs: walking, bathing, toileting, dressing, grooming, what we call transferring, getting up and out of bed or getting up and out of a chair. Literally everything you did this morning, those are functional activities of daily living, right? This morning, you got out of bed, you walked to the bathroom, you used the bathroom, you got dressed, you ate, you groomed. Everything we do in the morning that a lot of us take for granted, some people need help with that. And if you need help with that, again, it's not medical. So therefore, Medicare and your health insurance is generally not paying for it. So why is paying for the long-term care such an issue? And the bottom line is one thing: it's all about the money. Home care is less than nursing home care. However, it can add up very, very quickly because weeks can become months and months can become years. So what you're looking at on the home care side, and really this is what's called a personal care aid coming in to help, an aid coming in to help with those activities of daily living. Hourly, you could be looking at an agency bringing in a licensed, insured, background checked aid for 22 to 30 bucks an hour. And that may certainly add up to $200, $300, almost $400 a day, which can easily translate in $8,000 to $12,000 a month for home care. Times that out by 12, you can hit $130,000, $140,000 a year for home care. Now, nursing home can be double that. All right. Just as a rule of thumb, we as elder care attorneys do all we can to help keep our clients within their own home. That's our goal. That's our objective. Sometimes it's not the most plausible. It's not safe, perhaps, for the client, or it's not safe for the loved ones. So a nursing home becomes something to talk about. But again, home care becomes the target for most every client. And if you're paying for the care yourself, it gets very expensive very fast. So how can we pay for the care? Well, like we just covered, you can use your own cash, your savings. But if you're hitting $100,000 a year, even if you had $300,000-$400,000 in a nest egg, that's going to go. All right. So using your own savings is certainly possible. And quite honestly, it's used in the beginning. There's a continuum of care. People just don't jump on 24/7 care or jump on nursing home care. There are stepping stones. And quite honestly, in the beginning, the family helps out, or perhaps somebody down the block, the children, the spouse. I mean, I grew up in that time frame where my parents and my aunts and uncles did everything they could for both sets of my grandparents in the 80s and the 90s. So I know how much children run around and how much they try to help their families deal with their long-term care issues in the home. So there's a continuum, and perhaps there's some time before you have to hire somebody. So it does add up, but it does add up slowly, but it does add up big if it continues on. So cash is often not the best option. Then there is what's called long-term care insurance. That is a significant resource. That is a separate health insurance policy that you can purchase, provided you qualify health-wise and provided you have the ability to pay for it. It's not everybody has it, and those that do have long-term care insurance, as we've seen, the vast majority of them do not have robust enough benefits to cover the full cost of care in a home or assisted living or in a nursing home. All right. So the third and final way that people pay for home care, and quite honestly, it is the payer of long-term care for the middle class, it is community Medicaid. Community Medicaid is and has been a godsend for New Yorkers for decades. I've been doing this since 1998, and we've been working with that program for 23 years. It has been a very accessible program, a pretty comprehensive program, and again, a godsend to help keep people at home paying for care. Now, it's gotten more and more complex and more complicated throughout the years, the last 6, 7 years in particular. And what we're seeing again between last year and this year is another level of complication, all right? And that's what we're going to be talking about today. So what exactly does community Medicaid pay for? What do they cover? As I mentioned a moment ago, they will send in a personal care aide for hours that they approve. It is one of the most important reasons that you need an experienced advocate to assist with different healthcare assessments during the community Medicaid process. And I'll talk about that a little bit because that's what's going to dictate the amount of coverage, the amount of hours you're going to get. There's also a level of case management. There can be what's called medical transport for doctors' offices appointments. You could be looking at adult daycare that can be covered, supplies for incontinence, for example, as well as podiatry, audiology, dental services. So community Medicaid, which is now a managed long-term care program, has other benefits than just the aid coming in to help your spouse or your parent, all right? It is, again, MLTC, Managed Long-Term Care. That's the agency that is the one that's actually in the trenches providing the care. Now, current Medicaid eligibility for community home care benefits. In order to talk about the changes that are coming and to try to put some clarity on the update and the implementation, let's just get a little grounded on what is currently the situation when it comes to Medicaid eligibility. Some of this will be changing, some of this won't be changing. But in essence, as I tell my clients every single day, Medicaid eligibility is about three things. It is about your assets, it is about your income, and it is about your care level. How much care do you need? Is it at home or is it nursing home? If it's at home, how much care do you need? Do you meet the threshold of requiring long-term care? All right. But to talk about in order, on the asset side, somebody applying for community-based Medicaid is allowed to have $15,900 in their assets, in their resources, in their accounts. This is not income. This is not an annual number. This is money in the bank. It includes checking, savings. It includes investments, includes non-qualified annuities. It includes cash value of life insurance. It excludes your primary residence, which you don't want to leave in your name anyway. You still want to protect it. And by the way, since I've been doing these webinars for the last 12 months, we have them all on our website, tullyelderlaw.com. Go to videos and click on webinars. And the reason I'm bringing that up now is because we talk about the different types of trusts and asset protection vehicles that we can use to shelter your assets to become eligible for Medicaid, okay? So again, you can have your primary residence, you just don't want it in your name. You want it sheltered and protected in an irrevocable trust. In addition to this $15,000 number, you're also allowed to have retirement accounts. That can be your 401k, your 403b, a qualified annuity, an IRA, a Roth IRA. All of those are exempt from Medicaid asset calculations as long as you are taking what's called periodic payments, meaning those annual minimum distributions, those RMDs, which means 72 years of age and older. If you're under 72, then we have to start the payments annually in order for those accounts to be exempt, okay? So income, what we're talking about there is a maximum of $904 each month, okay? Again, it's a low number, but I'll talk a little bit more depth about the assets and the income on the next couple of slides. Now, on the care side, how do they determine whether somebody's eligible on the care side? It all comes down to what I mentioned in the first couple of slides, those activities of daily living, okay? Now, to break it down further, current eligibility on the asset side. How do we protect our assets so that we can become eligible? A moment ago, I mentioned an irrevocable asset protection trust. That is the most flexible, most solid, comprehensive tool that we have to shelter assets. And the beauty of current Medicaid eligibility rules is that there is no look-back period and there are no penalties for asset protection when you're applying for community Medicaid. So we are free under current law to utilize irrevocable trusts, transfers, and gifts to family without incurring a look-back period and without incurring penalties. So what is a look-back period? Well, the way I explain it to clients is because it has never existed in the community setting, I'm going to talk about it where it does exist, and that's in the nursing home setting. So if somebody was to apply for a nursing home, in a nursing home and apply for nursing home Medicaid, what's called chronic care Medicaid, there will be what's called a 5-year look-back period. That is a review of all of the assets, all of the accounts over the 5 prior years that the applicant is looking to get Medicaid to pay for the care in a nursing home. So for example, if we have, today's March 24th, if we have today as the Medicaid pickup date, if you will, that we want Medicaid to start paying for the nursing home, go back 5 years. You're going to be looking at March of 2016. And what we as the law firm do first, the attorneys and the paralegals, what we do first, and then the Medicaid agency does second, is literally we have to review every page of every financial statement of every account that you own, you and your spouse, for the last 5 years. The purpose of this complete review is to determine if there has been any asset protection steps. Have you funded an irrevocable trust? Have you given assets to your children? If you did it within the 5 years and it wasn't what's called an exempt transfer, which is a whole nother talk, then there will be a penalty. And the penalty is based on time. What, again, Medicaid says is for every $13,400 that is gifted or protected during the look-back period, Medicaid will not pay for the nursing home for 1 month. So if Mrs. Smith gave $130,000 to her son, Andrew, in 2019 and is applying for a nursing home in 2021, the look back will go back to 2016. They will see that $130,000 gift to the son in 2019. They will then do a calculation, 130,000 divided by that 13,000, what's called a regional rate of nursing home care, and that will give us the number of 10. That number 10 is the amount of months in which Medicaid will not pay for the actual nursing home because of the asset protection that was undertaken during the look-back period, okay? So again, a look-back period exists for us first, but then for the Medicaid agency to see if there were any gifts and asset protection steps. If so, during the look-back period, they will be penalized so Medicaid doesn't have to pay, okay? That's what a look-back period is about. And to bring it back to where we are right now, community Medicaid does not have any look-back period and does not have any penalties. New York State is the envy of most every other state in the nation. I've got colleagues in nearly every state, and they cannot believe that we've had it this way for years, okay? But that is on the asset side. If you wish to know more about the irrevocable trusts, again, go to our website, tullyelderlaw.com, to videos and webinars, and scroll down, and there's a couple different webinars that talk about asset protection, including the trust. All right, if you have questions, put it in the Q&A box or the chat box, and I'll get to it when I'm done. All right, thank you. Now, current eligibility when it comes to the income. Remember, Medicaid eligibility, assets, income, and care level. All right, so we just talked about the assets under the current situation, the current law. Now, on the income side, that second category of Medicaid eligibility is income. There is a maximum in the home care community setting of $904. And by the way, all these numbers go up every single year a little bit, not a lot, just a little bit. So $904 is the maximum that somebody is allowed to have in monthly income. All right. Most folks have a number greater than $900 a month in monthly income. So what do? Well, we utilize a tool called a pooled, P-O-O-L-E-D, supplemental needs trust. That, again, is a wonderful tool to shelter income so that we can help keep our clients and your loved ones at home in the community for longer. They can keep their income to pay their living expenses, pay their housing expenses. So a supplemental needs trust, in general, is a safe harbor, generally, when it comes to Medicaid. The pooled aspect means, the way I explain it to clients, is it means it has to do with income and home care. All right. So if you see pooled supplemental needs trust or pooled income trust, that's about income protection in a home care scenario. Now, in addition to the $904, every person applying is allowed to keep any health insurance premiums that they utilize. Okay. So if you're paying $300 a month for a supplemental, Medicare supplemental, your new number is now $1,204, all right? And then the amount over that is the overage that has to be sent to, every single month, sent to the pooled income trust, and they will then use that money to pay any bills that are in your name to keep you in the community, all right? And again, I talk about this on other webinars, and I'll probably do another webinar just on this soon because it is a complicated issue, all right? But again, another godsend. It's a great way and the only way to shelter excess income. Now, finally, Medicaid eligibility, currently, assets, income, and now care. How do we get enough hours approved? On occasion, we'll have clients come in or Zoom with me and they're saying, Mom needs 24/7. No attorney out there, no Medicaid service is able to guarantee the amount of hours that Medicaid will ultimately approve. How can you ensure you're going to get the most hours possible? That's through advocacy. If the assessment is scheduled with the New York State nurse or the MLTC nurse that's coming in to evaluate your mom, for example, and there is no preparation, if there is no advocacy at the time of the assessment, then that nurse may actually skip or not see, not record some of the actual needs that your mom has, and therefore receive a quote unquote lower score, which means we got less hours. The way that we practice is very unique. And we've been doing it this way since 2008-ish. We have geriatric social workers on staff to literally advocate for each of these assessments to help the family get the most hours of care, therefore help them get the best care possible while they're at home. It is a very unique hands-on type of service where the attorneys focus on the legal and the financial aspects, and the advocates, what we call care coordinators, are advocating, assessing, coordinating, intervening if there's any types of problems. But it's because of that role that, again, we fulfill, because we have these 3 care coordinators on staff, that we will advocate to help your loved one get the most care, the best care possible. So that's how it is now. What's going to happen after this? What's going to happen after the new law is implemented? So that's where we're going to go next. first things first. This new law, as I mentioned in the beginning, was signed into being last April. It impacts community-based Medicaid only. In general, well, I'll let the slides handle it as we go. What's being impacted? Well, community-based long-term care services. It is home health care, everything we're talking about to keep mom or dad home safely. It is private duty nursing. It's personal care services. It is what's called the assisted living program. In a nutshell, there's about a half dozen different assisted livings on Long Island that actually accept community-based Medicaid for room and board and a level of care. Not a lot of them, and probably not the ones you're thinking about, but it is a valuable program, but it applies to that as well as what's called consumer directed. Some of you may have heard that. Consumer directed is where you hire your own aide, can be a child. It has some merit, it has some good value. Especially during the pandemic when aides themselves were sick or quarantined, then there was a shortage of aides for many, many families across New York, and I'm sure across the nation. So consumer directed is where you can hire your own person. All right, that's still available, but again, these new rules will impact it. So what is the new law? Well, unfortunately, it is creating a look-back period for home care. Biggest and most important rule is they are creating a look-back period for home care. It is a 30-month look-back period. Nursing homes, 5 years or 60 months. Community Medicaid, 2.5 years or 30 months. Now, you remember my definition of a look-back period. To see what assets were transferred or protected during the look-back period so they can what? So they can penalize you. So, and from what we know and what we've seen, it is going to be the same exact divisor, that $13,400 for this year. Again, next year it'll be up a little bit, and each region in New York State's a little different. Of course, Long Island is the most expensive, but New York City is a little different. Westchester, et cetera, and further parts north and west, different numbers. But 13.4 is our number for Long Island. So there will be a penalty calculation if there was an asset protection step or any type of transfers or gifts during the look-back period. In addition, and this is a frightening part for a lot of families, the new law not only impacts the legal and the financial aspects of what we do and what the families have to endure, but it also impacts the care, which, by the way, and humbly, we are very prepared for because we've been handling the care issues in a united way with the lawyers for 12 years. So we deal with these care issues intimately for every family that is a client dealing with these concerns, dealing with what we call life care planning. So higher care needs is going to be a difficult hurdle for a lot of families to jump. However, if you have the advocacy and the coordination, we'll be able to navigate through the entire new long-term care system. All right. So what exactly are the changes? How is it happening? Now, when is it happening? Let's ask that question. So the way the law was written back in April of 20 was that all applications for community Medicaid filed after October 1st of 2020, all right? So last October, any home care application filed after 2020 will have a 30-month look-back period right off the bat. So that was overwhelming for a lot of us and a lot of families, because here we are in the summer of 2020, of course, dealing with the pandemic and a lot of other issues. And now they're telling us any community Medicaid application filed October 2nd, there's going to be a look back going 2.5 years back into 2017. Not fair to those that did irrevocable trust in 17, 18, 19, because the law didn't exist at that point. So there was a tremendous pushback. They then got together, the state came out with an amendment. And what they did was they did two things. They postponed the implementation of the new law from October 1st until January 1st. And they shortened or decided to phase in the look-back period. So no longer is it an automatic 30 months. The look-back period will begin October 1st. That's what we're talking about. So the second iteration of this, again, is any applications after January 1st of 21 will have a look back 2 months to October of 2020. Then the pandemic continued, and there was a postponement of the implementation from January 1 to April 1. It was another quarter, another 3 months had to pass. Reason being is that the way New York is interpreting certain federal mandates is that as long as there is a public health emergency, New York State is not allowed to make the Medicaid program more restrictive. And that's what this law does. So they weren't able to implement it in January. They therefore postponed it to April 1st. Now, in February of this year, with an April 1 date for implementation and an October 1 date for look back period begin date, in February, the federal government extended the public health emergency through the month of April. It's about April 21, I believe. Therefore, based on what I said earlier, with the public health emergency going through this second quarter of 2021, in essence, they will be unable to begin, New York will be unable to implement the new law, the new look back period, the new penalties on April 1st. However, we do have verbal word from the Department of Health that it is going to be postponed once again. So this is the update. We have this verbal communication from the Department of Health, and it's been over 30, 60 days since it's come out. And so there hasn't been any changes to it. So I'm comfortable now saying July 1st is going to be our implementation date because we're still in the public health emergency, right? It's not in writing yet. So every client we're talking to, every family we're meeting with, we are looking at July 1st, but understand it's not in writing yet. So we are we're slightly cautious. Obviously, April 1st is next week. So we will know more next week, okay? The look back period, still October 1st, okay? So again, where we're standing today, the update is we're comfortable saying July 1st is going to be the implementation date, not yet in writing, so asterisk there. And the look back period will go from July 1st back until October 1st. What does this mean? What does this mean for families that have long-term care health needs and want to stay home? It means that we are in the middle of a window of opportunity, all right? Literally. From today, because if you haven't started the application process, if you haven't started your life care plan yet, if you haven't started your Medicaid work yet, you have until today through June 30th to protect your assets and apply for community-based Medicaid, because it is not being implemented, not in writing yet, it's not being implemented until July 1st, okay? That is, again, what we are expecting. So what does this mean practically speaking? I'm still meeting with families every day. I have colleagues meeting with families every day. And there are assets to protect. There's a home to protect. There could be an investment account. There could be family savings to protect. This window of opportunity means this very clearly. For those that need care, you must act quickly to protect and shield those assets before and file your community-based Medicaid application before July 1st. That is the window that we have, April, May, June, all right? If you were to file the application after July 1st, and if the law is implemented, then there will be a look back period going back to October 1st. And if you sheltered your assets in that 9-month window, there will be penalties and waiting periods, just like the nursing home. All right. So it's very important that you consider this window of opportunity, with our asterisk, of course, as far as not seeing it in writing yet from the state. But we are pretty comfortable because the public health emergency is being continued for another month at this point through mid-April. All right. So what are the changes on the care side? The changes we just spoke about, the look back period, the penalties, that's impacting the legal and the financial aspect of community-based Medicaid. But like I said, there are some serious changes coming on the care side. There's 6 of them that families are going to have to endure and deal with and navigate through once this law is ultimately implemented. The first change deals with the activities of daily living, okay? As I've mentioned in the very beginning, long-term care, it's about walking, bathing, toileting, dressing. The current law, as we're assessing and advocating for clients with current clients and current applications, is we have to demonstrate a need with two activities of daily living. It's pretty gray. It's not X, it's not Y, it's demonstrate a need with two activities of daily living. All right. And through our advocacy skills and through our clients being real, we're able to jump that hurdle and get our clients approved and receive hours of care. Now, they're changing that, of course. What they are doing is making it harder. All the more reason that advocacy is required. What they're saying is limited assistance. We have to demonstrate limited assistance with a new phrase here, physical maneuvering with more than two ADLs. That's 3+. So we have to demonstrate physical maneuvering, not yet defined because it's not implemented, but we can imagine it's somebody literally holding or guiding, literally helping transfer up and out of a chair or out of bed. So that is what we're going to be looking at. It's a higher threshold. Again, all the more reason that we need advocacy to assist during this process. Now, they did do one good thing with this new law. They have finally acknowledged those with Alzheimer's and dementia. So those that have an actual diagnosis with Alzheimer's or dementia, the physical threshold with the ADLs is diminished. What we have to show when we have a diagnosis is a need for supervision with more than one ADL. This is a much lower threshold because a lot of clients and family members with dementia and Alzheimer's don't have that great of a physical need, but they have the need for supervision, right? So the idea here is let's help those families, and thank God, and it's finally here. So this is a good thing. Now, getting back to the care side of it. The ADLs, I just covered it. It's going to be harder unless you have a diagnosis. New York State is going to be bringing in an independent physician. If you've ever been in a motor vehicle accident or personal injury action, you have these IMEs, right? An independent medical exam. This might be like that. So instead of a doctor contracted with an insurance company, you're going to have a doctor contracted with New York State. I don't like this for several reasons. Primarily, that doctor contracted with New York State is not going to know my mom. He's not going to know, she's not going to know what my mom's needs are. Mom's primary physician, family physician, primary doctor will know. That is the best doctor to outline mom's needs. However, the state is going to require a doctor that doesn't even know mom to fill out a form. I can't imagine them doing a physical in-person assessment, but we'll have to see as this rolls out. I've said it 4 times already. All the more reason for advocacy. There's going to be a unified assessment tool, a uniform assessment tool. Again, not necessarily a bad thing like the others. This is going to hopefully standardize as these doctors and nurses are assessing our loved ones and determining how many hours of care will be approved. Okay, could be a good thing. They're talking about an independent assessor. So right now there are different nurses coming in from these MLTC agencies, but perhaps this is going to be an assessor using this new assessment tool, also contracted with New York State. New York State is trying to control the scenario. And, families are going to be going into this machinery, if you will, on their own, without legal guidance, without care advocacy, and it can be difficult. So it's why we do what we do, to protect the assets, to get Medicaid to pay, and to help your loved one get the best care possible. These next 2 changes are going to be a little complicated as well. There's talk of using the word safety, the concept of safety for your loved one in the community. So they're going to perhaps judge whether it is still safe for your loved one to even be in the community. That sounds very complicated. It sounds very difficult. Who's to judge risk? Who's to judge my independence and autonomy as to me wanting to live in the community? And not to mention, the safety issue would probably disappear if Medicaid would just approve more hours. So a lot needs to be seen with that topic as this rolls out. And again, hopefully nothing that more advocacy couldn't help fix. Finally, on the care side, high-hour consumers are going to be referred to a different type of panel, if you will. Those we are foreseeing with 12 hours or more of home care will get reviewed for what? Is it a safety issue in the community? Is it a financial issue? Is it a matter of saying we're paying, for 13, 15 hours a day of coverage, 24/7 hours of coverage? We'd rather you go to a nursing home. It's fraught with concerns, and we don't know how it's going to roll out, but we know we're going to be fighting it when it does. Okay. So those are the care changes. Legal, financial, and care changes are going to be coming in the new law. Now, for years, I've been doing this since 98. I would say since 2004, I've been focusing on three things: legal, financial, and care. That's how we've grown. That's how my practice has been built. So when we come on board to help a family, there's three things you have to focus on. The legal aspect of how do we protect the most assets possible? The financial aspect, how do we get that care paid for? Typically by Medicaid. Medicaid is the payer of long-term care for the middle class. It's the way to go for the vast majority of families, subject to eligibility, subject to protection, subject to assets, income, and care needs, like I've been talking about today. All right. Now, the final point: how do we help our loved ones get the best care possible? That's what makes us so unique. For us, the care that your loved one needs is just as important as protecting the house. For us, the care that your loved one needs is just as important as getting Medicaid to pay the bills. When you talk with other law firms and see the services that they provide adequately and sufficiently, and some of them are darn good, but they're only focusing on the legal and the financial. A lot of those firms are leaving the care portion up to the family. When you come to work with us, we are looking at the entire person: the legal needs, the financial needs, the care needs. I have a unified approach. The legal and the care come together. The attorneys and the paralegals protect the assets, protect the income, get Medicaid to care. And the advocates are there intervening if there's a crisis, advocating during assessments, guiding the family through the long-term care maze. In my opinion, and in my experiences with my own family, it is the only way to deal with these long-term care issues. So, as I try to wrap up here, what does all this mean? Two things. Again, take action now if you are that person in need of long-term home care. The clock is ticking. In addition, take action if you are that healthier senior, not in need of care. Take action now as well so that you can do your asset protection, get that look back clock running, 30 months going forward for home care, 60 months going forward for nursing home care. So whether you're a healthier senior or one in need of the care, you got to get moving. All right. Doing things in advance will help avoid the crisis. All right. So again, it's been my honor to share our Wednesday webinar with you. If you have questions, I will check the chat. I'll check the Q&A. You can always shoot me an email or call the office. Email is Brian, BRIAN, at Tully, TULLY, elderlaw.com. Phone number is 631-424-2800. All right. We're here to help. Now, let's see if we have any questions. I've been told I explain things good, but there needs to be some questions. All right, here we go. If I already have an irrevocable asset protection trust, will I need a separate pooled supplemental needs trust, or is that a part of the irrevocable trust? My income is more than 904. Great question, Nancy. The answer is yes. You will need both types of trusts. And nobody ever said getting old was easy or not complicated. The irrevocable asset protection trust is just that, an asset protection trust. The pooled supplemental needs trust, also known as a pooled income trust, is for income. So in an ideal situation, you establish the irrevocable asset protection trust in advance, get the look back going. That's the only trust you need to do. When there is a need for long-term care in the home during the Medicaid application process, that's when the pooled supplemental needs trust is going to be applied for. That's when that is going to be formulated. It's already in existence. There are a number of pooled income trusts already in existence in New York State, run by charities and nonprofits. It's actually a pretty good system. There are thousands and thousands of seniors that use these every single day. We deal with them every day. So pooled trust, yes, you have to do it, but it's only when you're actually applying for Medicaid. Okay. Okay, a question. I didn't talk about this today, but the question talks about a power of attorney. It really does apply to this, so I'm glad the person brought it up. The power of attorney is the financial document, probably in line with the irrevocable asset protection trust, the second most important document there is. It needs to be modified. It needs to be expanded and made comprehensive so that your power of attorney agent can do the asset protection and do the income protection and apply for community-based Medicaid or even nursing home Medicaid. It's only through that power of attorney where those things can be done if your loved one doesn't have or does have diminished capacity. Now, interesting, timely question is, or the answer is, New York State, because they like to keep things moving, is changing the power of attorney law, all right? You can't do all the things we're talking about today for a lot of families and a lot of individuals without a sufficient, comprehensive, modified power of attorney. But again, they're changing it come June, mid-June of this year. There's going to be a new form. So for all of those clients of ours that we've set the new powers of attorney up for recently, we will be updating those come the fall when we're comfortable with the new form and all the language that's built into it. But those of you that don't yet have a power of attorney, get one. If there is no power of attorney in place, the family could be forced into what's called a guardianship. If there is a power of attorney in place, but it is not sufficient, the family could be forced into a guardianship. You don't want your family going there. And again, I've done webinars on this, power of attorney versus guardianship. If you go to the website, you go to videos again, click on webinars, you will see the webinars talking about the benefits of a POA, the need for it, versus why you want to stay away from a guardianship proceeding, okay? Any other question? Okay. When are we going to know what's going on with the implementation date for community Medicaid? I don't have a magic crystal ball, and none of us do. The reality is we were expecting a more firm answer by now. We don't have it. April 1st, like I said, is next week. We will know, I would imagine, don't quote me, but we'll know come April 1, April 2, whether this is actually happening, because we would need instructions, we would need the counties implementing it and accepting applications in a different way. But again, we're fairly confident because of the Department of Health's verbal communication that we are still in a public health emergency through April 21st. So therefore, the implementation will be rolling out July 1st, okay? Might it be postponed after that? Perhaps, I don't know. I don't know. Will my power of attorney automatically be modified, or will you reach out to your clients? It's very hard for any law firm to reach out to individual clients. What we will be doing is notifying the world through social media and through emails that the new power of attorney law is implemented. The new powers of attorney do not replace the old ones automatically. If you have an older power of attorney and it has all the right language, it should still be valid. That's what we're expecting. But there are some benefits to the new one, which once we see the form, we'll be able to determine whether it's worth updating. Bottom line is we will expect it to be worth updating because it's supposed to be simpler and it's supposed to have some teeth built into it. So if a bank or an investment company says, we're not going to honor your power of attorney, we as attorneys can get involved and they'll be responsible for our legal fees. That's what we've read. That's what we're expecting. I will be doing a webinar in April, May, forgive me, a webinar in May on just the power of attorney issues, because by then we'll have the form and have a lot more input. All right, check out please, our event page on our website. We're now booked out a month in advance for different topics, okay? So we'll be talking about revocable trusts, we'll be talking about wills and probate. Every Wednesday, 1 o'clock, that's what we're shooting for. May will be a little choppy with that. Forgive me, April will be a little choppy with that, but come May, we'll be here every Wednesday, okay? Again, thank you. It was my pleasure. And if we can help you in any way, please let us know. Thank you. Here we go. Stop that. Stop that. And here we go. Thank you.